Hi there, contract student, and welcome back to our sixth and final lesson in this sequence on contract interpretation. If you want to follow along at home with notes, illustrations, and examples, you can order a copy of my contract interpretation slidebook at the link below. Also, we're going to be starting on page 600 of the casebook. The Parol Evidence Rule, or the PER, is a really big topic, but the analysis proceeds in a two-step process. So I broke the discussion into two parts. In the previous lesson, I introduced the Parol Evidence Rule, and I explained the first step, analyzing the nature of the written contract. Now I will explain the second step, analyzing the nature of the evidence introduced, and then integrate our understanding. So let's get started. Remember, the Parol Evidence Rule governs when a court will admit extrinsic evidence to add or modify the terms of a written agreement. Extrinsic evidence includes preliminary negotiations, course of performance, course of dealing, uses of trade, anything that's not written in the four corners of the document. When a contract is partially integrated, the court will not admit evidence that modifies an express term. And when a contract is fully integrated, the court will also not admit evidence that adds a term. That's relatively easy to say, but significantly harder to apply. So let's get to work. And let's return to the cases we covered in the last lesson. First up is United Auto Workers. In this case, the court found a merger clause was plain and unambiguous. Even the dissent agreed with that. The majority took a strict, formalist, objective view of contracts. So it found the contract was completely integrated. Next, we asked, what is the nature of the evidence to be introduced? UAW wanted to introduce evidence of preliminary negotiations that the parties agreed that the Doral Resort would be staffed by union workers. What is the nature of this evidence? This evidence is seeking to add a new term. There is a contract about the use of a resort for a conference, which include terms about number and nature of staff. Nowhere in the writing is the union representation requirement spelled out. The plaintiff is suing to prove it had the right to cancel the contract because the staff was non-union. So it's trying to introduce evidence of an additional term. In UAW, remember, we have a complete integration, which means we cannot admit evidence of additional terms. Therefore, the court excluded the evidence and found for defendants. In Sierra Diesel, this was the case about the bookkeeping machine, the computer. Remember, there was a merger clause, but the court took an anti-formalist, subjective view of contracts and found the parties didn't really intend the contract to be integrated. The buyer of the bookkeeping machine sought to introduce evidence of preliminary negotiations where the seller made promises about what the machine could do. Since, according to the Sierra Diesel court, the contract was not completely or even partially integrated, the buyer can admit that evidence. And now in Middletown Concrete, this is the case about the pipe-making machines. There were three contracts, each having a merger clause. Since three documents cannot all be the complete and exclusive statement, or can they? As a side note, why didn't the court interpret the writings as a whole? But in any event, the court found the contract was final, but not complete and exclusive. What evidence was to be introduced? The acceptable performance letter, which specified how much pipe the machine would make per minute. At first blush, this might be seem like it's adding a term, not modifying a term, because the contracts did not discuss how much pipe per minute the machine would produce. If the nature of the evidence is to introduce a new or additional term, the contract is only partially integrated, that evidence could come in. But that's not what happened in this case. What happened in this case? The Middleton contracts had an additional term in the writing. They each had a limitation of warranties clause as well, saying, quote, the foregoing warranty is exclusive and in lieu of all other warranties. And on the reverse it said there are no rights, warranties, or conditions other than those herein contained. The buyer was seeking to introduce the acceptable performance letter and show how the seller had made warranties or promises in addition to those found in the contract. Accordingly, the acceptable performance letter, which contained these additional promises, contradicted the written contract, which said there were no additional promises. Since the contract was a partial integration, a buyer could not introduce evidence that would modify a term. The offered evidence contradicted an affirmative sentiment in the writing. The acceptable performance letter's pipe permitted promise contradicted the contract statement that there are no promises other than those stated in the contract. So the evidence is excluded under the Parol Evidence Rule. There are 5 categories of evidence that are not excluded by the Parol Evidence Rule. So let's talk about those briefly. First, the Parol Evidence Rule does not exclude extrinsic evidence which shows the meaning of an ambiguous term. Courts may defer on whether they admit extrinsic evidence to determine whether a contract is ambiguous, but once ambiguity is established, courts will generally consider any relevant evidence that resolves that ambiguity. Second, under the UCC, course of performance, course of dealing, and uses of trade is always admissible. Similarly, common law courts that apply the subjective theory of contracts and permit extrinsic evidence to show latent ambiguity. Likewise, courts under the UCC will admit evidence of course of performance, course of dealing, and uses of trade to show the meaning of contractual terms. Terms that become part of the contract through actions or trade usage under the UCC are considered part of the original agreement, so they're not considered to be added terms and not excluded by the Parol Evidence Rule. In this way, course of performance, course of dealing, and uses of trade is distinguished from and prioritized above preliminary negotiations. Third, evidence of subsequent modification is not barred by the Parol Evidence Rule because parties are generally free to agree to modify their contracts. The Parol Evidence Rule does not prohibit parties from changing their contracts in the future. As a general rule, contracts are not set in stone, although many do have no oral modification clauses or other limitations to contract modification. And of course, the pre-existing duty rule may also bar contract modification under some situations. We'll return to the concept of subsequent modification with the Muther-Ballinger case. Fourth, the PER does not bar evidence of collateral agreements. But what is a collateral agreement? A collateral agreement is one that was not intended to be part of the contract. What a court considers to be collateral, however, is not always clear. We'll return to the concept of collateral agreements with the Seagram and Sons case. And fifth, the PER does not bar evidence of flawed contract formation. If the contract was not really formed because it was signed under duress, fraud, mistake, etc., then the contract cannot be integrated. In fact, the contract doesn't exist. Returning to our case, in Muther-Ballinger, a medical partnership bought a CT scanner from Griffin Electronics. The purchase contract included a merger clause and a limitation of warranties term, stating that, quote, there are no warranties expressed or implied except as set forth in this agreement. The contract did not specify whether the scanner would be useful for spinal scans, but when Griffin came to service the scanner, Griffin made a number of specific representations that the scanner would produce diagnostically acceptable spinal scans. Even though those promises that the scanner would produce spinal images contradicted the written contract because the contract said there were no additional promises, the evidence was admissible. Why? Because it showed oral modification subsequent to the written contract. In Seagram & Sons, Harold Lee agreed to sell his liquor distributor to Seagram & Sons, and during preliminary negotiations, Lee conditioned his agreement to sell on Seagram's promise to relocate him and his sons to a new distributorship in another city. The contract for the sale of the distributorship made no mention of relocation, but the court admitted the evidence of preliminary negotiations anyway. Why? It found that the agreement to relocate Lee and his sons was collateral to the distributorship sale agreement. It came to this conclusion because it found that the relocation agreement was not one which the parties would ordinarily be expected to embody in the writing. And why is that? First, the distributorship sales contract was between Seagram and 5 co-owners of the distributorship, but the relocation only pertained to 3 of those co-owners. So it would not be expected in the sales agreement that pertained to all 5 co-owners, they would talk about a matter that only dealt with 3 of them. Second, Lee negotiated the relocation agreement with the Seagram Executive Vice President Jack Yugman, who Lee had known for many, many years. The court found that this close relationship of confidence and friendship made it reasonable for Lee to think that Yugman would honor his handshake deal. Third, the sales agreement did not contain an integration clause, and so it was susceptible to introduction of additional or modifying terms. And fourth, the relocation agreement did not contradict the sales agreement. So that's the Parol Evidence Rule. Let's review. First, we determine whether a contract is a partial or a complete integration. The existence of a merger clause or an integration clause is very good evidence of integration, although it's not always dispositive. Formalist courts take an objective approach that almost always finds a merger clause evidences a complete integration. But anti-formalist courts take a subjective approach and admit extrinsic evidence to determine whether the parties intended the contract to be complete and exclusive. If a written agreement is final or partially integrated, it bars modification of written terms. If a written agreement is complete and exclusive or completely integrated, it also bars additional terms. Evidence that shows the meaning of ambiguous terms is not barred by the Parol Evidence Rule. The Parol Evidence Rule does not apply to ambiguous terms, only to clear ones. Evidence of course of performance, course of dealing, and uses of trade is also admissible to show the meaning of terms, even ones that are patently unambiguous, at least where a contract is governed by the Uniform Commercial Code. Evidence of subsequent modification is not barred by the Parol Evidence Rule, although it is subject to the pre-existing duty rule. Evidence of a collateral agreement is not barred by the Parol Evidence Rule either, but it can be hard to distinguish what makes something collateral versus expected to be part of a written agreement. And evidence of problems with contract formation is also not barred by the Parol Evidence Rule. If the contract was not formed, any merger clause in it would not be binding. So now you know about the interpretation of express contract terms. Thanks for tuning in, and keep contracting.